Welcome and thank you for standing by for today's conference. All participants will be in listen-only mode until the question-and-answer session. At that time, to ask a question, please press star 1. Today's conference is being recorded. If you have any objections, you may disconnect at this time. I'd now like to turn the conference over to Brian Beams. Sir, you may begin.
Thanks, Melinda. Hello, everyone. On behalf of the U.S. Commercial Service, the Connecticut, New Jersey, San Diego, and Imperial District Export Councils, and the Law Office of Robinson & Cole, we welcome all of you to today's webinar titled An Overview on the Foreign Corrupt Practices Act. My name is Brian Beams, and I'm an international trade specialist with the U.S. Commercial Service. I am your co-host for today's webinar. Joining us is my colleague and co-host, Anthony Sargis. Anthony will be emceeing the Q&A portion of the webinar. A couple of items to note. Be sure you are connected using both your telephone and the online WebEx platform. All telephone lines are currently on mute. We will open the lines up for questions at the end of today's presentation. We will also take questions submitted through the Q&A feature on the WebEx platform. Final note, our web address has changed. Please note that all U.S. Commercial Service information can now be found on www.trade.gov. Again, that's www.trade.gov. I'd like to take a minute to inform the audience about the U.S. Commercial Service. We are the trade and investment arm of the U.S. federal government, a division of the International Trade Administration. Our mission is to promote U.S. exports, protect U.S. interests abroad, and facilitate foreign direct investment into the United States. We have a domestic and global reach. Domestically, we have over 100 offices nationwide. Internationally, our offices are located within the U.S. embassies and consulates in over 75 countries. Here is a list of the remaining webinar for our series. Note, all 10 webinars are being recorded, and those the recordings and presentations will be forwarded to you every Friday morning, no later than 9 a.m. Eastern Standard Time. I now would like to introduce today's speaker, Ed Heath, who is a partner with Robinson & Co. Ed routinely advises institutional clients in connection with civil and criminal government investigations and enforcement activities, including with respect to issues involving the Foreign Corrupt Practices Act and the False Claims Act. His work has involved working with many U.S. federal agencies, way too many to list, as well as various state attorney general offices and other administrative agencies. As a result of his experience, Ed is often called upon to conduct internal investigations for companies and organizations domestically and in Europe and Asia, to provide guidance on matters of corporate compliance and litigation risk. His clients include a wide span of industry, such as tech, manufacturers, financial, healthcare, and to mention educational, charitable, and religious organizations. Ed is also works with a professional associations such as other law firms and accounting firms, municipalities, judges, and media personalities. Without further ado, I welcome Ed Heath. Ed?
Thank you very much, Brian. Well, good afternoon, everyone, and welcome to today's presentation on the Foreign Corrupt Practices Act. Today, the FCPA is probably one of the most significant federal tools for enforcement. Not a week goes by without a media headline that some company will be paying 8 figures or sometimes 9 figures or more to settle FCPA claims. Any company who does business internationally needs to understand the FCPA and to take meaningful steps to ensure that they're complying with it. For those of you who are viewing online as well, you'll see we've got the PowerPoint slide up that's got my smiling face on it. And next to my smiling face is the agenda for today. I've broken the session into 4 parts. In part 1, we'll start with an overview. I'll talk about the development of the FCPA, its scope, who it applies to, and the exposure that it can create. In part 2, we'll go over the elements of an FCPA violation. I'll try to use hypotheticals to put those elements into context. And along the way, as we go through those hypotheticals and talk about the elements, I'll suggest how a compliance policy might be tailored to address some common misunderstandings or common traps for the unwary. In part 3, I'll address 2 very common misconceptions that I often see And it's those misconceptions that often lead businesses to think they can circumvent FCPA liability, when in fact those mistakes typically lead to FCPA prosecutions. Finally, in Part 4, we'll cover the practical aspects of FCPA compliance. And by that I mean specifically what the government expects with regard to corporate compliance, as well as the features of an effective compliance program. Now, I saw the attendee roster for today, and I see that we've got a mix of lawyers who are in-house, lawyers in private practice, and compliance officials. And so I've tried to tailor the presentation so that every one of those groups is able to get value out of it. I won't go too far into the legal weeds, but we will address sort of the key legal topics as we go through. The session today is scheduled to run until 2:30. After about 30 or 40 minutes, we'll stop and take a 10-minute break for Q&A, kind of a halftime break. If there's some good questions that I get submitted through the web, I'll try to address some of those. But it sounds like we're also going to open up the line for some live questions. We'll resume, as I said, after about that 10-minute break, and then we'll go until around 2:30 when I'll stop and leave time for additional questions at the end. Last housekeeping point I have is that obviously today's seminar doesn't create an attorney-client relationship with any attendees, and that at no point am I intending to give legal advice about any particular situation. So with that, let's turn to the substance. Whoops. Okay. So I want to talk a little bit about the history of the FCPA. I could start by saying here are the elements of an effective compliance program, but I think that without a little bit of the history and a lot of the context, me listing the elements of a program now wouldn't be that helpful to you attendees, so I'll come back to that at the end. So the FCPA really finds its origin in the mid-1970s. It has its genesis actually in Watergate. Foreign bribery landed on Congress's radar around the mid-1970s due to work that was begun by the Office of the Watergate Special Prosecutor. And then there were follow-up investigations by the SEC, that's the U.S. Securities and Exchange Commission, and by the Congressional Subcommittee on Multinational Corporations. For you history buffs, that's Senator Church's committee. Through that work, it was discovered that corporate financial records were being falsified. They were designed to disguise or conceal the source and the application of corporate funds that had been misused for various illegal purposes. It was also discovered that the slush fund concept was very common, where money was dispersed outside the normal financial accountability system. And those funds were often used for questionable international transactions. Several multinational corporations failed to report to their shareholders millions of dollars of such payments, offshore payments, in other words, illegal bribes. And the SEC got involved because they were concerned about violations of U.S. securities laws. Congress got involved because it was concerned about foreign policy considerations, about economic perceptions, and really a failure of global leadership. So in the PowerPoint, you'll see on the second bullet on the current slide, I've included a really great quote from President Carter that sums up this motivation, which is essentially post-Watergate national morality when he signed the FCPA into effect in 1977. However, the Reagan administration didn't see much of a use for the FCPA. And so pretty much from its initial inception, the FCPA remained a fairly dormant enforcement tool. That all changed in the mid-2000s, as we'll examine a little later. First, let's talk about the scope of the FCPA. So this is a federal law, which means it's enforced not by state authorities, but by federal authorities, and specifically two federal agencies, the DOJ and the SEC. Now, in short, the FCPA prohibits U.S. companies and their personnel and their agents from bribing foreign officials to get or to keep a business deal or opportunity. I've listed here the elements of a violation: a payment of anything of value to a foreign official with a corrupt motive or improper purpose for the payment. And we'll examine each one of those in turn in Part 2. For now, I don't think any of you will be surprised to hear that federal regulators, and often judges, take a fairly expansive view of each of those elements. Those elements are not interpreted as narrowly as you might think, and they're also not usually defined in the ways that you might think. There are a lot of sort of hidden concepts and nuances to them that companies and their personnel can find themselves in trouble with. Now, keeping in mind the history of the FCPA that I talked about a moment ago, and the SEC's concerns about transparency to shareholders. I want to point out that the FCPA also imposes specific requirements for publicly traded companies with respect to their corporate records and their internal controls. So who must comply with the FCPA? Obviously, the company itself has to comply with the FCPA. And as we'll examine in a minute, the failure to do so can lead to not only criminal or civil consequences, but also pretty significant practical consequences. In addition to the company's employees and agents individually are subject to prosecution, civilly and criminally. And I want to emphasize that it's even domestic employees here in the U.S. who may be subject to those civil and criminal penalties. So, for example, say that you have a VP of sales in your offices in Manhattan, and that VP sitting in her office in Manhattan gets on the phone and directs a sales rep in India or Russia to pay a bribe to a government official to get a business deal. That VP of sales herself individually may be prosecuted under the FCPA. Finally, your intermediaries and your agents abroad, they too may be subject to prosecution if they're acting on your behalf to conduct or to facilitate the bribery. So the penalties. This is usually the part of the presentation that when I do it live tends to completely suck the air out of the room because the penalties can be so severe. What makes the FCPA such a hammer is these provisions and the costs that are associated with an investigation. So as I said, companies and their personnel are subject to civil and criminal liability under the statute, and the criminal penalties can be severe. For companies, we're looking at up to $2 million per violation. So arguably, if 5 bribes are paid over the course of a few months, each one of those constitutes a separate violation, even if they all potentially lead to the same deal. For individuals, you're facing up to $250,000 in fines per violation, as well as up to 5 years in prison. Now, to make matters worse, the individuals have to bear the payment of that penalty on their own. Insurance from the company can't reimburse them. The company itself can't provide reimbursement. So there's real danger here for corporate officials to go to jail and to face pretty significant fines that can be crushing. Now, it's not in the PowerPoint, but it's important to remember that the accounting requirements under the FCPA can trigger criminal penalties as well. And these are actually much more severe. It's up to $25 million for public companies and up to $5 million and 20 years in prison for individuals per violation. That's the criminal side of it. There's also a civil side. Significant fines exist there for accounting and record-keeping violations. For companies, up to $750,000 per violation, and for individuals, up to $150,000 per violation. So the penalties are bad enough, but you really have to keep in mind what are the practical consequences beyond simply what I've listed here. And there's many of them. First, the FCPA violation, an FCPA violation can result in debarment of the company from government programs, disqualification from programs, disqualification from doing business with the government. An FCPA violation can also result in the loss of certain export privileges. The government can cut off the lifeblood of a company in this way. Company may also be required to disgorge or forfeit profits that resulted from the improper payment. So if you get the deal, but you get it through a bribe, and you provide the benefits, you get the profits, it can really hurt the company because the company has had to provide the benefits. If it's equipment or services or whatever, they've been provided. The company has absorbed that cost. But the company might be forced to give up all the profit that was associated with that. Now, once there's an investigation, it's probably going to go on for quite some time, and the company needs lawyers. And it's important to remember that it's not just the company who typically gets lawyers, but a number of company officials as well. And the company typically picks up the tab for those officials. There's a long process that goes along with the investigation. They're often negotiated, or there often is a settlement negotiated, and the settlement results. Sometimes those cases go to court. The cost is potentially hundreds of thousands, if not millions of dollars in legal fees. At the same time, you've got internal disruption and cost. You have personnel who have to participate, who have to assist the lawyers, who are interviewed by the government. Records have to be produced. Those costs can easily skyrocket. In some instances, a settlement results in the imposition of a external monitor. For those of you not familiar with this concept, that's where a third party is paid by the company to essentially monitor its activities. The third party observes, investigates, and reports out on what the company is doing. And you get to pick up the tab for that. That can go on for years as well. There's also the negative publicity and the impact on the company's goodwill. Now, granted, most companies that go through FCPA settlements, they come out just fine on the other end. Their reputation isn't destroyed, but it still lingers, and it's got serious consequences. Now, there's not only government litigation that can follow from an FCPA violation, but we're seeing more and more as a trend shareholder litigation, derivative suits brought having to do with FCPA violations or potential FCPA violations. Finally, you're looking at potentially being sanctioned in the other country where the bribery occurred, country or countries, I should say. Sometimes those schemes cross borders. And more countries are pursuing those types of violations. So ultimately, the consequences can be severe. And, the DOJ began to realize several years ago that it needed a stronger deterrent. So if I were doing this presentation 15 years ago, I wouldn't spend much time emphasizing the risk to individuals, the risks of prosecution, that is. But more and more over the last really 10 years, DOJ has stepped up and turned up the heat on pursuing individuals. It's become a lot more aggressive, and the government is insisting on jail time as a part of settlement. And keep in mind that the vast majority of companies, or I should say corporate and individual defendants, settle with the DOJ or the SEC. And those individuals who settle, they could be looking at years of house arrest or imprisonment. So again, it's something that has really changed the landscape of federal enforcement over the last 20 years. I put some statistics up on this next slide. You'll see that back in 2000, there were a total of 3 DOJ and SEC enforcement actions. Frankly, if you were to rewind it even further and you'd look at it from 1980 to 2000, for virtually every year you'd have maybe 1 or 2, in some years no DOJ or SEC enforcement actions. But the tide began to turn slightly in the early 2000s. And by 2005, that annual figure hit 14, as you see, and then it really began to climb in the years after that. The number of actions has pretty much remained consistent over the last 10 years. And, you might think that the Trump administration's DOJ will cause these matters to become less common. I can tell you that hasn't been the case, as you'll see with 2019's figure of 49. In fact, all signs indicate that enforcement will continue to remain on its current pace. Now, you might think that the number is small, right? Only 49 cases nationally. But consider the total sanctions that have been recovered. If you look back to 2000, you're looking at $1 million annually. The number began to climb, and now it's in the billions. So, 49 enforcement actions, $2.9 billion. Some of those are carryover from year to year, so the numbers don't match up. But we're talking about, major dollar impacts to resolve one of these cases. As you'll see on the table on the side of this slide, all major industries have been targeted for FCP investigations, including, the ones you'd expect: aerospace, defense, industrial manufacturing, oil and gas. Oil and gas is one of the biggest. But also some you might be surprised about, such as consumer goods or financial services or healthcare. They are just as active as many of the other categories. All right, let's shift from talking about the bad things that can happen and turn to the statute itself so we can begin to focus on how to avoid these kinds of adverse consequences. So turning to the elements, let's start there. Essentially, this is what makes a violation and how it can be avoided. I've listed the 4 elements here, and as I go through the elements, we'll return to this slide, but as I focus on each different element. So we're going to start with the element of the payment. We'll begin with a hypothetical. Since I don't know if everyone's looking at this on the web, I'll read it out. So you're at a U.S.-based company that manufactures aerospace components, and you're seeking to sell those components to a large government-owned entity in India. one of your sales representatives on the ground in India offers an executive of that government-owned entity a $5,000 cash payment to induce the sale. We all know, that there's an FCPA violation, most likely right there. But there's a tweak. The executive refused the offer, and the sale was never made. So the question is, has there been a payment in violation of the FCPA? Option A is yes, there has been. B is no, because the executive refused the payment. And C is no, because the sale was never made. The correct answer is A. There has, in fact, been a violation. So a payment occurs, or I should say the FCPA prohibits making, promising, or offering the payment. It's important to keep in mind that money, or the thing of value, as we'll talk about in a minute, doesn't actually need to change hands. Merely offering the payment is enough even if it's rejected. Promising the payment is enough even if circumstances develop that the payment is never actually made. The deal gets called off, the deal is refused, the deal falls apart, whatever it may be. The mere fact that offer has been made is enough to be a is enough to satisfy this element and potentially be a violation. Obviously, the Department of Justice is more likely to invest resources prosecuting a consummated payment, of course. But if you're sitting in your office contemplating whether to make a payment, a legal payment, or direct someone to make it or stop someone from making it, you're just not going to know what the government enforcement priorities are at that moment, or how your situation, your individual circumstances might fit into the broader goals of the particular DOJ office that's got jurisdiction for your company at that moment. I have a corporate client now that's being pursued for something that under the Obama administration would likely have been resolved fairly quickly. I'm not even sure the government would have initiated the investigation. But due to the current administration's priorities, the DOJ is pursuing this matter aggressively and appears to be digging in and seeking a pretty severe result. And there's no way to tell what the political realities are going to be in the particular office at the time. You've got to be conservative. You've got to keep in mind that these offers can be dangerous, and they may cause the DOJ to act. So in every FCPA training that I do for our clients, and at the start of virtually every FCPA investigation that I'm involved in, I get given the line that's the title of this next slide. I'm told, but bribes are business as usual in country X. Well, that doesn't make a difference here. The FCPA prohibits bribes even if they're ordinary course of dealing in the country, even if it's an everyday activity. It doesn't matter. The FCPA just doesn't care what goes on in that particular country. So if you've got your internal business people or your internal salespeople, and they're telling you we can't do business in country X without paying a bribe, just know that that's not going to be a defense. It's not going to matter to the DOJ when they launch their investigation. There is built into the FCPA an exception for what are called facilitating payments. These are really the small bribes that get paid to foreign officials to trigger routine, non-discretionary actions to kind of move something along, get an application or a license or a registration through, get something through border control or customs. And, believe it or not, on the face of the FCPA, those types of payments are permitted. And compliance officers and lawyers sometimes see that part of the FCPA as giving a green light to making those payments, and therefore allowing the company policy to permit those types of payments. But I will tell you, in my opinion, in my experience, it's just not a safe practice. The law with respect to facilitating payments is not perfectly defined. It's not well defined. So it's going to be impossible to draft any policy that gives exact legal guidance on when a payment is merely a facilitating payment or crosses the line into an actionable bribe, a corrupt payment. I've yet to see a reported case or decision or been involved in one in which that provision was used as an effective defense. And think about it. You're delegating to someone in the field the discretion to decide whether to make a payment that's likely illegal in the country at issue. These are still bribes after all. And so what if you have a provision in your compliance policy that allows a facilitating payment, all it's really going to do is water down your FCPA compliance. It's going to blur the line. It's going to delegate decision-making in a way that is very dangerous. So as we go through, I'm going to offer policy considerations, and here I'll offer one that you should expressly prohibit payments that are intended to facilitate or expedite actions by government officials. You should have an express line in your policy that says we may not do this. Now, there are two other exceptions to the no payment rule, so let's talk about those. I've had clients who say to me, we had no choice, we had to pay. So it's essentially a duress argument and maybe even an extortion argument. The law recognizes there are two kinds of duress or extortion: economic extortion and physical extortion. And what I mean by economic extortion is you'd hear something like this. Without this deal, the financial consequences would be severe. You know, we'd have to let employees go. We'd have to, close the company down. Without the government taking action X, the company could be in dire economic circumstances. Well, it doesn't matter how dire the economic circumstances are. It's simply not a defense under the FCPA. You will get no traction with the DOJ saying that the hardships will be insurmountable. We'll be out of business. Our employees will be let go. We needed this deal. Absolutely does not matter. There is no economic duress defense under the FCPA. Physical duress, physical extortion is treated differently. Where you've got a situation where you have to protect your employees or their families against imminent danger to their physical safety, the government has issued guidance that says that's different. That gets treated differently. They're generally speaking not going to view that kind of payment, what we call the gun to the head type payment, as violating the FCPA, because it's not done with a corrupt motive. It's done to prevent imminent bodily harm. So the policy consideration that I recommend here is to require, or I should say first start by having a policy that explains what economic duress is and what physical duress is or extortion, and make very clear that economic duress is not permitted. I will tell you, I hear from clients all the time the statement that, well, what about when it has to be done? What about when it's going to be really bad for us financially? People really do think that's a defense, and it's not. So you've got to explain that in black and white in your policy. And at the same time, you want to require that all threats of extortion, whether they're economic or they're physical, be reported to the compliance officer. Now, there is another exception built into the FCPA. That's an exception when written express local law permits the payment. But this is just another one of those exceptions that I think gets people into trouble. What it requires, in other words, is that the foreign country's law clearly and unequivocally permits the payment to be made. But I want to be clear, custom is not law. It doesn't matter if it's the way things are done. That's not the law of a foreign country. At the same time, the opinion of the foreign official asking for the bribe is not an opinion on local law. I had a client once say, but they said it's okay. It doesn't matter what they say. That official could be committing a crime, could be your co-conspirator or your employee's co-conspirator. So the policy consideration is that if the payment has been requested or appears necessary because it's customary local law, that the representative or employee should get the compliance director and or the legal counsel to provide written confirmation that the payment is okay. So let's go to the next element after payment, which is anything of value. Again, let's start with a hypothetical. So Mr. X is an executive at a state-owned company in China to which you want to start selling your products. Now, in the course of closing the deal with you, Mr. X mentions that his son is a business major at NYU, and he hopes that you can take his son on with an unpaid summer internship. You pause to think about that, and you realize that, well, every year you take on an unpaid intern. And Mr. X's son happens to have an outstanding resume, so he's right in line with the kind of intern you take on, and you haven't taken on an intern yet, so you agree to take the intern on. Question is, may that internship be considered anything of value under the FCPA? The options are A, no, Mr. X hasn't received a benefit, so it can't be anything of value. B, no, because the internship is unpaid, so this person's essentially doing you a favor. C, no, it's not anything of value because the internship is consistent with your own past practices. And I could add to that that the candidate also has the type of resume that would make you want to hire him anyway. And finally, D, yes, it is something of value. The correct answer is D. It is, in fact, something of value. Anything of value doesn't just mean cash in a paper bag or money wired into an account. It also includes entertainment, travel expenses, gifts, charitable contributions, political contributions, and yes, internships. And the benefit doesn't have to pass directly to the foreign official. It can be to his family. It can be really anyone else, if the government could potentially trace an indirect benefit to the official. So here, obviously, Mr. X wants his son to be successful, so a summer internship with your company is obviously important to his son's success, or he wouldn't have asked you, and so therefore you've indirectly benefited Mr. X, who falls into the category of a foreign official. You know, I've mentioned here that, that charitable contributions, and of late, I think that's pretty significant. So for those of you on the front lines of these issues, I think we're going to see some FCPA prosecutions that arise from charitable contributions. And here's the scenario that I have in mind. A lot of COVID-19 related charities are popping up all over the world, and they may be used to funnel benefits to foreign officials. I'm not suggesting that, true legitimate charities are going to do this. I'm thinking more of, dummy organizations that on paper look like they're charitable organizations and can collect, those charitable contributions. So, say that your company makes, charitable contributions all the time, and one of your sales reps comes to you and says, hey, in country X where we want to do business, there's this there's this great charity and it's helping people, and I'd like us to make, contribution to that. Your past practices in terms of making charitable contributions don't matter for these purposes. You need to diligence that contribution, diligence that organization to see what you can find out. You've got to ask questions about the entity and really verify that it's a legitimate entity that's actually helping people and is not just a way of funneling a kickback to some foreign official in that country. As I said, I think we're going to see some prosecutions of that sort down the road. So you're probably asking yourself at this point, so can we give anything at all, any kind of gifts, any kind of benefits? And the reality is that the FCPA has no built-in de minimis exception. There's no dollar threshold, no conceptual threshold written into the law. So on its face, the answer is no, there aren't any expenses of any sort, no gifts, no payments, no benefits to any foreign officials that would be allowed. But there's no shortage of guidance out there, not just from case law, but also from the DOJ and the SEC that tells us in practice reasonable good faith expenses are permitted. They may be allowed. I've listed some examples here in the PowerPoint. Low-cost promo items, pens, mugs with the company logo. You can have occasional reasonably priced meals and entertainment. Yes, concerts. Yes, sporting events. Taxi fare to and from business meetings, some travel expenses. These types of things are all specifically called out and permitted under the, under the DOJ guidance that exists. Essentially the DOJ is looking to see whether the gift is likely to cause, a reasonable foreign official to abandon his or her duty. And it's when the gifts kind of cross a line and become extravagant that that's a problem. Frankly, there's a very blurry line between reasonable and unreasonable expenses that you've got to watch out for. So going to the next slide, the policy consideration here is to have express dollar limits built into your compliance policy, limits that employees are not allowed to cross without advance permission, and if they're going to propose crossing that line, that crossing has to be diligenced by the compliance director. And those expenses that are in fact doled out have to be supported with detailed documentation, the who and the what the money was spent on. And when I talk about dollar limits, I'm really talking about, actual numbers built into the policy, both, on an individual basis, on an annual basis, and on a per transaction basis. So they're aggregated limits as well. And somebody's got to be in charge at the company of monitoring those expenses. But I will tell you, where I've seen companies that don't build those dollar limits into their policies, there's all sorts of confusion. No one knows whether something is extravagant or not. You've got to keep in mind that all sorts of expenses do fall into these categories, and they do need to be monitored. All right, going back to the elements. Next element is to a foreign official, which has a slightly broader meaning than you might think. So going to our third hypothetical. You're at a social function, and you're introduced to an executive from a hospital which is located in the Ukraine. You've never met this executive before, and you know nothing about the hospital. In the course of the discussion, the executive begins discussing with you a potential business arrangement between your company and the hospital, say sending generators over to the hospital, or a construction project or something like that. Should you A, treat this hospital executive as a foreign official, or B, just treat the executive as a regular private business person, because hospitals aren't government agencies? I'm guessing everybody knows the answer to this one. The correct answer is you have to treat the hospital executive as a potential foreign official under the statute, and that's because the hospital may be state-owned. It's important to keep in mind that the FCPA has a very broad definition of foreign officials, and it includes not just your typical government agency personnel, whether it went into the spectrum, you've got the president of the country, or a police officer, DMV clerk, customs official, someone with an official government-sounding job title that's analogous to the U.S. But it goes much broader than that. It applies to any employee of a government-owned or government-controlled business. And in some countries like China, that's virtually all businesses. You've got to just make that point clear to your employees, because people make assumptions all the time that if it's the type of business that's private in the U.S., it's probably going to be private overseas. So you really have to proceed with caution and give your employees clear guidance here. Also swept up into this definition are employees of public international organizations like the UN or the World Trade Organization, although I don't think you're going to be interacting with those folks too often. Bottom line is, when in doubt, your employees have to act in a foreign country as if they're dealing with a foreign official. So, final element is with a corrupt motive or improper purpose. We talked about this a little while ago in the context of extortion, where your employee is facing physical extortion or physical duress, and the government there believes, well, if a payment's being made, that payment is being done with the purpose of ensuring personal human safety, as opposed to a corrupt motive or improper purpose. But it really is, it's broader than that. So this box gets checked if the payment is being made to either obtain or hold on to a business advantage. A lot of times people think it just applies to get the deal in the door. But if payments are made during the course of the deal or to keep the deal or renew the deal, well, that is equally an illegal payment. And I've listed some types of examples here, which you can read under the first bullet point. It's important to keep in mind, though, that the value that's paid out is often less than the value that's actually received. And, you can't make a proportionality argument to the DOJ. It won't help you if your gift is an extravagant gift. If it's a small-scale gift, the type that I laid out before, okay. But once you start to go beyond that, you're not going to be able to say, hey, look, in the grand scheme of this deal, what we gave this official was pretty negligible. You can't say, this was a deal for $30 million in aerospace components. And the only thing we did is we let the official extend his stay in New York for 2 days for him and his wife to see the city. So it wasn't even $1,000 for those 2 extra nights. So you can't point to the $1,000 and say, look at that in the big scheme of the $30 million deal. That probably didn't persuade him. Well, putting the executive or putting the official up for 2 nights in a $500 a night hotel room just so he can enjoy the city is probably going to be considered as tied to a corrupt motive or improper purpose. It's arguable, but it's certainly not a position you want to have to be in, and you want to guide your employees how to avoid that type of problem or avoid getting in that type of position. Because remember, rarely is intent going to be proved through direct evidence. In other words, while it's great if the government can get it, but most cases aren't based off an email. that says to, the foreign official, we'll pay for, this hotel stay if you make sure we're awarded the contract. Those things do happen, but it's pretty rare. Don't make the mistake of believing, and don't let your employees make the mistake of believing that the absence of direct evidence will avoid FCPA liability. The government is not sheepish about building their case and proving through circumstantial evidence things like timing, the nature of a gift, the lack of a prior relationship, and other factors that there has been a corrupt motive here. All right, so before we go on to part 3, let me pause there and just check the list to see if there are any questions that have come in. But let me also ask the moderators if there's anything they want to mention now that we're going into halftime.
Yeah, Ed, thank you. Real quick, Ed, do you see 1 or 2 questions on the Q&A?
I have a notice that says there are 3, but I'm not having any success bringing them up here.
Okay, I see 1. So before we handle that one, Melinda, please provide the audience instructions on how to ask a question by phone.
Thank you. And at this time, to ask your question over the phone, please press star 1. Please unmute your phone and record your name clearly at the prompt. To withdraw your request, please press star 2.
Ed, thank you, Melinda. Ed, I will now ask you, or I'll read the first one. Maybe Tony can see the other 2 because he's the lead. But the first question is, does the FCPA
Brian?
also? Yes.
I was going to say, if it's the one about how are foreign officials and individuals and representatives accountable, I'm actually going to get to that one a little later in the presentation.
Okay. That is the one.
Okay.
So let me move back to Melinda. Melinda, do you have? Did anybody prompt for phone questions?
Thank you. At this time, we are showing no phone questions.
All right. Tony,
I just see one other question. Yeah, I see the other one here. All right. Does the FCPA also apply to U.S. government officials as well as they may influence contracts with foreign actors?
That's a good question. I don't believe that it would apply to U.S. government officials. I believe there's a different statutory scheme that would apply to U.S. government officials.
All right. Thank you, Ed.
Yep.
All right. We'll go one more time to...
I think we have another one coming in here, too, and we can see if Melinda has any, but let me see if there's another one written in.
Great.
And no phone questions on this side.
Thanks, Melinda.
Not sure if you're going to get to this one later also. It says, how does the FCPA apply to foreign affiliates, distributors of U.S. companies with no direct or guidance from the U.S. company?
Yes, I'll get to that one as well a little later on.
All right, perfect. All right, then we can, if we don't have any questions on the phone, we can move forward with part 3.
All right. So the FCPA realities. The question that I most often get is, can't we just let a third party do the bribing for us, especially if we don't ask any questions about what they're doing overseas? It's kind of like the don't ask, don't tell, or bury your head in the sand type approach to this. So the FCPA applies to anyone who acts on the company's behalf, even if the person is not an employee or even if the person is not a contracted agent for the company. What often happens is the company will say to me, well, this person wasn't really our agent. We didn't have any kind of written agreement with them. They certainly weren't our employee, and we didn't know what he or she was doing. And the fact of the matter is that's just not going to be enough. They can reach they can reach that kind of conduct. The theory that you can bury your head in the sand, that you can turn a blind eye to it, just is not an effective defense. Intentional ignorance will not protect you from a prosecution. The concept is called willful blindness. And essentially, if you've got a scenario where there are, red flags that were existing, and they don't have to be screaming red flags, they can simply be, red flags that appear in the transaction, that is enough to potentially trigger FCPA liability. So third-party due diligence really is necessary, as you can tell when you've got your agents who are acting overseas. It's the kind of thing where 15 years ago, if you were to send a questionnaire or you were to suggest sending a questionnaire over to your overseas agents, you'd probably get a great deal of pushback and likely no answers to those questions. That has changed. I know that I've had clients say to me, if we send this questionnaire over, we're never going to get a response from our agent. And most of the time when we hear that, what comes back very quickly is a completed response with all the detail that we've asked for. And we're talking about not only the other names that the business can operate under, but the ownership structure, the governance structure, the names of the principals of the company or the agent, the individuals who work for the company that will be involved in your business, relationships that exist between that third party and government entities or government officials in the country and other individuals, the criminal and the civil legal history of the company and its principals. Have any of the principals been convicted of a crime in the past? Is the company currently under investigation? These are the types of questions that the federal government expects you to answer or expects you to get answers to. And it's really become so much more commonplace to get those. And, even in some countries where you might think you're not going to get answers to these questions, you'd be surprised that you do get the completed questionnaires sent back. You'll want to make sure that as a part of this third-party diligence, if you can, there's training of those third-party representatives, the same type of training typically that your own employees would go through. It may be a little more limited in that you don't really have to go into some of the accounting provisions, but training nonetheless. And, whoever is in charge of gathering this due diligence should be submitting it up to the compliance director to get approval for it. There should always be in your contract an anti-FCPA provision that makes clear to your third-party agents that there's an FCPA and what the basic elements of it are, and that they are expected to abide by that. So let's talk about the red flags. Red flag is anything that could raise a suspicion of corruption, and they're defined and they're considered very, very broadly. The most simple one is, what country are you dealing with? There's a great index called the Transparency International Corruption Perceptions Index. I've cited it here in the PowerPoint, which you can look up online, and it gives you details about which countries are known for the highest incidences of corruption. And if you're doing a deal with someone in one of those countries, that alone is a red flag. You're doing business in China, you're doing business in Nigeria, you've got a red flag there. And you have to approach the transaction carefully. But there's also more granular types of red flags, and I've listed some of the examples here. Frankly, there's anywhere from 20 to 40 common red flags that exist. You have, for example, requests for reimbursement where the expenses are poorly documented. There's a piece of paper with a number written on it. Would be a good example of that. Meals where you're told there were, it was a $300 bill for a meal somewhere. And the cost of living in the country is significantly below the U.S., so that it might be the equivalent of a $1,000 or $2,000 meal, which on its face may or may not be problematic. But then when you try to figure out how many people attended this meal, you don't have an itemized receipt, you don't have a clear number. You simply have your sales agent telling you that, there were 12 people at this meal. Everybody from the company was there at this. 6 people from our offices, 6 people from the target company's offices, but there's no proof of that, no evidence of that. Well, that's a poorly documented expense, and it may be that the meal itself cost, $30, and the balance of the money that the person's seeking reimbursement for is just a kickback. Same thing with respect to payments for cash or an unusual advance payment. I've seen that where the consultant says, I've got great connections, and with this government office, and I can help get industry X, this government-owned industry, interested in buying your goods. but, I'm going to need, to advance me the cost of my travel because I'll have to fly to different places around China to get to a couple of different cities, and I'll need some hotel rooms. And, if you could advance me that money, I'll need that to make for an effective, 2 months or 3 months ahead of me. That may all be true, and it may all be perfectly defensible, and you may get documentation after the fact. But, if you proceed, you've got to proceed very, very carefully and make sure that you get the documentation on the back end. And particularly if there's cash involved in the transaction, I know prosecutors who would say that if there's cash involved in any significant sum, it is a screaming red flag. Same thing is true of discounts. If you've got, an unreasonably large discount to a distributor, to a third-party distributor, or a large commission, that could be a sign of a problem. And here's the way it plays out, right? You've got, you've got your distributor to whom, you're going to be selling this product for X number of dollars. And, built into that is a pretty significant discount. When it then gets sort of resold to the government entity, that discount isn't, is beyond what the distributor's typical profit might be. It's something far larger than that. So you wonder, why do they suddenly need this big discount? Well, they need the big discount because they're taking that difference not out of their bottom line, but they're taking that money to be a kickback to the government official. That unusual discounting is something, again, that DOJ officials will scrutinize heavily. So practice pointer, if you're hearing that there's a significant discount that's needed, that's your red flag. Dig into it and get a very clear explanation about the purpose from the distributor for that discount, why it's needed, and sort of vague protests about, higher costs of labor or, economic challenges should not be accepted. You need far more detail than that to greenlight that kind of a discount. And I think that really highlights the way to deal with these red flags is you don't want to delegate the authority to resolve them to your salespeople. It should be something that goes to the compliance director. And if you educate your personnel on red flags and what to look for with red flags, the process should be they spot the red flag, and ideally they spot it because not only are they educated, but the example is listed in your compliance policy. So you turn to the policy. Your salesperson sees this scenario specifically listed as a red flag, so there can be no denying, no willful blindness, no head in the sand by the salesperson, and then he or she elevates that to the compliance director. You don't want the employee really doing too much of their own due diligence into the red flag. You really want that due diligence to be led by the compliance director, because you want to be careful of what the employee is putting into an email, is requesting, and what type of information they're accepting and what type of information they may be blocking. So the employee should be taught to immediately alert the compliance director, hey, there's this red flag. The compliance director should step in and guide the employee on what information to request and what information to follow up on. And at the end of the day, no payment should be made. The transaction itself shouldn't be completed until each and every red flag is resolved. It's not going to be enough to say there were 5 red flags and we worked through 3 or 4 of them. The fact that there were multiple red flags is a screaming indicator of a potential FCPA violation, but it's not going to be enough to just resolve a couple of them. That'll be willful blindness right there. Okay, so another quote that I hear all the time is, what happens in Thailand stays in Thailand. Oh, well, it's overseas. The government here is never going to find out about it. We shouldn't be worried at all as long as our people here, didn't have a direct hand in it. And the truth is that, the activity may all occur outside of, the bribing may occur outside of our border, but, your foreign representative or even the foreign official who gets the bribe may be turned by law enforcement against you. For those of you who know how law enforcement works, this isn't going to come as a surprise. But for those of you who don't, a very common approach in federal law enforcement is to target, for lack of a better phrase, the low man on the totem pole. Get the person at the very bottom and have them, face severe penalties and have them roll up and cooperate and incriminate the person who's one step ahead of them. And so that can kind of work its way up the food chain till it gets all the way back to your executives, here in the U.S. And, that you never know if that local official might be caught up in a sweep, some sort of anti-corruption enforcement in his or her home country. And that official, may quickly realize that, he or she has been taking a lot of bribes from a lot of different people, but here's this, great, well-known American company with a spotless reputation that he or she can trade up to local officials who can then, inform, DOJ officials here in the U.S., and your company may just be that juicy target. And that may be enough to get that foreign official out of trouble in his or her home country. And there is significant international interagency cooperation. That wasn't really so much the case in this area, at least 20 years ago. But, many of these companies are stepping up their anti-bribery, anti-corruption enforcement. And they're communicating with U.S. regulators, getting trained with regulators in the U.S., establishing sort of joint operations committees. So there is a dialogue that's ongoing back and forth. And just, you don't want to think that what happens, in some far-flung country is going to stay there. And at the same time, you've got to keep in mind that here in the U.S., the DOJ has very, very expansive investigatory powers, the grand jury subpoena process. They can issue subpoenas to get documents and other information. They can compel people to come in and testify, all as a part of their investigation. In other words, the charges don't need to be filed. The DOJ has this subpoena power and can get testimony done just in the course of their investigation. And believe you me, people cooperate when the federal government comes knocking. And through their subpoena power, the government has the ability to get not only at company technology and company devices, but also the personal devices and personal email accounts and personal bank accounts of individuals. And they do cast a very broad net. They're able to get really all non-privileged communications. And the only privilege that's likely going to protect you, or is likely going to be protected from disclosure, I should say, is the attorney-client privilege. We have a saying, emails are God's gift to trial lawyers. Hopefully none of you are surprised to hear that phrase, and none of you are surprised to hear that employees will put the worst possible, most incriminating things into an email. Sometimes those emails are explicit, sometimes they're not explicit, and they try to code it, but those codes are rarely sophisticated enough that the DOJ isn't able to crack them. I can't tell you how many indictments I've read over the years where the DOJ lays out the fact that a code was adopted by the group of conspirators, and here's the way the code worked. People just aren't as clever or as sophisticated as they think that they are, and the DOJ is very good about unwinding those types of things. And so, what we saw after there was a flood of emails that were incriminating to people and people were getting educated on the emails is employees would shift using text messages. There are also some, international messaging apps like, WhatsApp and the like, and there's others that people use. WeChat, I think, is another one. But what we're seeing more and more is text messages being the primary incriminating evidence of people. People think, well, I know they can get my emails, but this is my iPhone and it's got a text message on it, so I'm safe in sending that out. But they just aren't, and you need to make sure that you're educating your employees about that they may decide to facilitate their scheme not through the company's computer but their own personal phone, and that personal phone is not going to be off limits. And some of you may be familiar with cases where the employee throws the laptop into the river or damages the hard drive, and they think, they'll never get me now because I've wiped it clean. Well, the forensic technology that exists is far more sophisticated than it was, even 2 or 3 years ago. I personally have been involved in cases where we've defended entities or we've been representing entities that have done internal investigations where we have forensically reconstructed data. And the DOJ does it all the time, and they will do it, and they can get a hold of that data. And also the individuals who attempted to destroy the data, whether or not they're successful, face an additional array of federal felonies by virtue of their obstruction. Now, there's a powerful incentive that exists out there to people who want to be whistleblowers. I'm sure you're all familiar with, Dodd-Frank, which was passed into law by President Obama, or signed into law by President Obama back in 2010. but what you may not be aware of is that it provides a whistleblower bounty. Someone who reports a securities law violation to the SEC, and that could be an FCPA violation, hiding the illegal payment on your books. That person who comes forward can get a bounty. They get a chunk of the settlement. If the settlement or there's a successful enforcement action that results in a payment of over $1 million, then that whistleblower can get between 10 and 30% of that money. There's a whole plaintiff's bar of lawyers that focus on representing whistleblowers. They know how to put the employee's story together. They know how to tease out the best information, and they know how to present it to the government in a way that gets the government interested in pursuing those claims. That is who you're up against. And at the same time, even if your company doesn't provide for protection from retaliation, Dodd-Frank provides that retaliation. And I will tell you, it's a powerful, powerful incentive. And believe it or not, foreign nationals can take advantage of this. The SEC, has issued guidance or has issued an order that says it doesn't make any difference whether the whistleblower is a U.S. resident or a foreign national, where the person resides, where the information came from. It was, sent over from overseas. The SEC just doesn't care. And the evidence bears that out because in practice, the SEC has paid out millions of dollars to foreign nationals for whistleblower awards over the years. I've cited here in the PowerPoint some of the more significant ones. The biggest one that I'm aware of was back in 2014, and it was one person for one set of cooperation being paid $30 million. That was their bounty. 2017, there was a $4 million one. In 2018, there was a $4 million one. Those are powerful, powerful incentives for folks to come forward to the government and report your company's misconduct. So I've ended this particular slide by saying beware the disgruntled former employee or former agent. They have information that can do some real damage to you. And so, I don't want to sort of suggest that you can't trust anybody or you have to be paranoid. The policy sort of consideration, the compliance policy consideration, I would suggest here, obviously doing all the things that make for a good compliance program are really necessary to avoid facing a whistleblower. But believe it or not, sometimes whistleblowers come forward simply because they don't feel like there's an outlet within the company. There's no one at the company who would listen to them. And so I will tell you, we'll talk about this a little more in a few minutes, but having an anonymous, reliable, meaningful reporting structure within the company that's coupled with an anti-retaliation policy that's promoted within the company is actually a very good way to deter whistleblowers. It won't catch every one of them because some folks are just opportunists with an axe to grind, but it can really minimize your risk. Not only in terms of somebody who thinks that there's no way for them to report and something has to come forward, but knowing that it's out there will help you catch and deter those potential violations. All right, let's go on to our last part. We'll talk about the practical considerations. If you aren't already convinced of the need for a robust compliance policy, I will tell you that the DOJ has made very clear that it expects companies to have a robust and effective compliance policy. And so I've listed here some online resources that you can go to if you're interested not only in learning more about the FCPA, but what the government considers makes for a good corporate compliance policy. And this is guidance that the DOJ frequently updates. In fact, it was the last entry here there, the DOJ's policy for evaluating corporate compliance programs was just updated earlier this week, and a number of changes were made to that document. And this link here will take you to the most current version of that. Our firm has a manufacturing law blog that keeps our clients up to date on what's going on out there in the world with respect to manufacturing law. And we're going to be doing a blog post next week on the latest modification to this the DOJ's evaluation document. So for those of you interested, you can reach out to me and I can get you set up with our blog. Going to the next slide, it's pretty clear here that the DOJ believes that any company who's going to do any kind of business overseas needs to have a written FCA compliance program. And the DOJ will take a good hard look at your compliance program to determine whether it's adequate and effective when they decide first do we conduct an investigation? And then second, now that we've got evidence of wrongdoing by company personnel, how do we resolve this investigation? They will look to see, do you have a good faith program that really does what it needs to do? And the quotes that are listed in this slide come directly from the DOJ's own guidance. Also taken from the DOJ's own guidance is the 3 fundamental questions that they ask. That's their phrase. That's how they characterize this. They consider these to be the key questions. And I would tell everyone listening that, whether you're, creating or updating, reviewing your company's policy or program, or you're advising a client on their policies, these are the questions you have to ask. And they're pretty generic questions. You can read them yourself. But if you have these as your starting point, and then you take a look at the DOJ's guidance, you can really get into whether or not we're hitting that adequate and effective standard. So, important transition point here is that these last couple of slides have all talked about these programs. From the perspective of what does the DOJ expect from your company? And the bottom line is they expect you to have an adequate and effective compliance policy. So you need to have one in place if you're doing anything internationally. If you're crossing U.S. borders, you've just got to have an FCPA program in place. But I don't want anyone to leave this call thinking, well, we have to have it because if we ever get in trouble, we want to be able to show it to the DOJ, show that we have one so we're fine. That doesn't really work. You can't pull it off the shelf, blow the dust off, and say, hey, we've got a policy here. That's not good enough. But more importantly, the reason to have this program in place is to prevent violations, to remedy violations, so that you don't even end up in the DOJ's crosshairs, that you don't end up getting the grand jury subpoena and having all the disruption and expense that comes along with it. And I can't tell you that having an updated, robust, effective compliance policy is a guarantee that you'll never have an FCPA violation. If there's one thing I don't underestimate, it's the ability of people who want to do something wrong to find a way to do something wrong, no matter how many times you may train them and guide them, and no matter how clear you make the consequences. So you can't eliminate that possibility, but you want to try to prevent it. And in my experience, these good, robust policies will deter most FCPA violations, because as I hope I've demonstrated throughout today, oftentimes the illegal activity is the result of a misunderstanding of what the rules are. And so I've tried to demystify or clarify some of the most common misperceptions so that those of you who are working on these policies can build them into them so that the operators out there can understand exactly what they need to do and what they're not allowed to do. And at the end of the day, if you do have someone who's a rogue employee, that may be the only defense that you have left. You may want to say, we tried. We had a really good policy. It was thorough. It addressed the current state of the law. People were trained on it. It was well communicated. We invested resources in it, and ultimately we had a rogue employee. Now, at least in most circuits, that's not necessarily going to be enough to protect you as a strict matter of federal criminal law. The actions of your employees, if it's done within the scope of their employment and to benefit the company, can still create criminal liability for the company. So you can have that policy, you can have that instruction, but they can still be trying to benefit you by getting you that deal. And sadly, that can be enough to get you, you caught up in a prosecution. But the lawyers at the DOJ take an oath to do justice, and everyone that I've met over the last 20 years takes that oath very seriously, and they respect it, and they do want to hear both sides of the case. And so, as a part of them exercising their prosecutorial discretion, they do want to hear about your training program, how robust it was, how complete it was, how updated it was, how effective it was. And that's really what that guidance boils down to. That, the line assistants, the frontline AUSAs, assistant U.S. attorneys, are being told by the Department of Justice, take a look at that policy, test it out, see if it's effective, because that'll tell you whether you really want to prosecute this company and how much, if at all, you want to penalize them. So with that, let's now turn to what are the common features of an effective compliance program. What are the things that the DOJ is really looking for? That alone could be a half-day seminar to get all the little nuances of it. But as you're looking at your policies, as you're reviewing them, if you go back and say, you know, we have one, but it's sitting on a shelf and we haven't looked at it in 2 years. You want to make sure it's at least got these basic elements. And once they do, you can start digging more deeply into how you want to develop them. But it starts with a communication from the top, a commitment from the top. This isn't something that you want to have circulated by, somebody who's, the number 2 person in HR. You want it to come from the very apex of the company if possible, because that's showing the company that, yep, this is our culture. This is what we take this serious. This is part of our principles, that you adhere to this program, that we don't tolerate bribery. We don't do business this way. And I always like to have, as a part of the training, either an in-person statement by that individual or something on video from that individual. But the written document should be something that is transmitted at least through a cover email or in some way from that person, so that everybody at the company sees that high-level buy-in. And nobody thinks, well, yeah, this junior person sent this along to me, but I know what the CEO really wants me to do. She wants me to close these deals, and I got to close these deals. That executive has to say, no, that's not what we want. And, sometimes that appears as a mission statement at the beginning of the policy. And so let me address that for a minute. I've had a number of clients over the years who say to me, we have an FCPA compliance policy in place. Here, I'll show it to you. And they hand me a document that's a page or 2 pages long, and it looks very similar to what they might plug into a contract that says we don't engage in bribery, and we don't do business through corrupt means. And it's a beautifully written, really nice articulation of those common principles of anti-corruption. And it sounds great, and it would look like a great public statement to make, a great press release to make. But at the end of the day, it provides no real practical guidance to anyone. And that's just not an effective policy. It's a nice policy statement. It's good to have. But without the operative provisions, I will tell you it's largely going to be a meaningless document. And that's why I say here in the second bullet point, it has to be clear, accessible, specific written guidance. When I started doing these types of compliance programs, I noticed that a lot of the policy statements and the procedures were very vague and generic, but they also were written in legalese. And as someone who commits that sin from time to time, I know that if you give employees a set of policies and procedures that are inscrutable, that just don't make any sense, that aren't at an 8th grade reading level, that's really what you should be striving for, that it's not going to do any good. It's not going to help them understand what they can and can't do, and it sure isn't going to help you when you're sitting across from the DOJ and they're assessing whether you have an adequate policy. That's why I talked about setting in specific dollar limits along the way earlier on, because again, without that clear guidance, you're not going to prevent or deter violations. You want to make sure it's consistent. You want to make sure it's not something that's been sitting on the shelf for the last 10 years. The law changes, as evidenced, as I said, by the fact that the DOJ issued new guidance just this week. And they do. They issue guidance from time to time. DOJ officials give speeches and lectures in which you can glean additional guidance. So you want to make sure it's an updated, evolving policy. It doesn't have to be reviewed every 6 months. An annual look is probably a worthwhile step. Now, it doesn't do any good to have a policy or set of procedures that your employees aren't trained on. And, if costs are tight, if money's tight, maybe you just train the most senior people. But ideally, you're training everyone who could potentially have that foreign interaction, from the salespeople who are boots on the ground to the accounting people to the people who are supervising them. You want to make sure that you are monitoring expenses and that you have good document retention around those expenses, that the documents actually have to be submitted and that they're maintained. And I also would recommend periodic testing. If you're the compliance director, or someone else, have an employee submit an expense reimbursement form that should create a red flag and follow it through the system. The DOJ is going to look to make sure you're doing that kind of testing, so you really should be doing it. And many times you might think you've got the perfect program in place, but if it doesn't work operationally, it's doing you no good and it'll get you no credit. Next, you want to make sure that you've got your comprehensive third-party due diligence. We talked about that earlier. Again, that means a questionnaire that goes out to the, your third-party agents and representatives. It's a detailed questionnaire. Make sure they complete it, return it, sign off on it. If you cannot get your third-party due diligence document back, you probably shouldn't be working with that person. And I've seen some pretty creative excuses over the years, and I've seen them come back with lots of blanks in it. I've seen it where the agent returns it with half the questions filled out and things like NA in other spaces where NA just doesn't belong, and which is sometimes have an employee who doesn't read the document, right? You get the employee who gets the document back and says, oh, it's signed, it's completed, here we go. But they don't actually read the responses. So make sure those responses are read and followed up upon until they're complete. Because the last thing you want to do is sit across from DOJ and say, hey, we did our due diligence. Here are these great documents. And as you're getting ready to produce them, you as the in-house counsel or the compliance officer are seeing there are these gaps in the document. You're not going to get a break under those circumstances. Again, you want to make sure you've got a responsible senior official. I always recommend that somebody within the company, somebody with real authority in the company, be designated publicly as the compliance director. Ideally, that's their only job, but in most mid-sized companies, you can't simply have a compliance director. So we've had it where the CFO or the COO, somebody else has that role, but it can't be someone so junior that they don't have authority to investigate, or that it's sending a message to the company. We really don't care. That's where we're making this sort of third string person our compliance director. It's got to be somebody senior who can be seen as getting something done. As I mentioned earlier, you want to have a confidential reporting mechanism. The reports don't just have to be anonymous. You want to set it up so it can be done either way, but you want to lay it out. It's got to be pretty simple and easy to use. I like 800 numbers. I like a compliance email address, a physical Dropbox, something like that. You got to make it clear that it's confidential, and if someone if it's an email or an in-person report, that it will be treated confidentially. You want to make sure your policy says that. And you want to make sure that you do that in operation. You really got to limit the number of people that are aware that a report has been made. But again, that compliance director has to have the not only the autonomy and the authority, but the ability to really pursue these potential violations. And he or she has to understand that they are meant to be investigated, and that they have access to outside counsel, if need be, to pursue those investigations. Because you don't want to have that official be sitting there on the stand or sitting in the interview room with the DOJ saying, well, yeah, I heard about it, but look, I've got 90 other things on my plate, and I don't really have somebody to help me out here, and I kind of got the sense the company didn't want me to rock the boat and go about interviewing people. No, you have to make sure the compliance director understands that if this report comes in, it's got to be investigated. People have to be interviewed, documents have to be reviewed. I'm not suggesting that every complaint requires bringing a team of outside lawyers. In fact, if the policy is well designed and the staff are well educated, the compliance director is well educated enough, in most instances you're probably not even going to need outside counsel until it's determined that there has been a violation. At which point you've got to weigh whether or not a disclosure needs to be made to the government. Very common nowadays for companies who identify a violation to make a self-disclosure to the government and to get the cooperation credit that comes along with that disclosure. But until you've done a sufficient investigation internally, you're not in a position to make that assessment about whether there has in fact been a violation, a likely violation, or whether or not it should be reported. And sort of the last point in this is, there has to be actual discipline and remediation. It's no good to say that there's a problem and ignore it, or determine that there's a problem and give somebody a slap on their wrist. There may need to be employees who lose benefits like bonuses. There may need to be reassignment of employees. There may need to be termination of employees and corrective statements issued and communications about the way that business will be done going forward. I've seen it happen where companies have had a great policy, they've had a rogue employee or a misunderstanding, and as much as you hate to draw attention to it, you can write that sort of vague communication company-wide that says, hey, circulating this new policy again, or circulating our policy again, I want to highlight that we've amplified our direction on point X. And I encourage everyone to read it and come to me if you have any questions, because we take this seriously. And if you don't take those steps, if you just sort of turn a blind eye to the problem once it's discovered, or sweep it under the rug, the violations or the problems are going to continue. And if you ever get caught by DOJ or the SEC, you're probably not going to get much credit for that. Ultimately, all of this is driving to one concept that the government's looking for and that a model company has, and that is a culture of compliance. If you take these steps and you're mindful of what the law requires and you have a robust program and you're committed to it, then you're going to develop that culture of compliance, which, if you ask any lawyer on either side of these cases will tell you, that's your best defense against violations and prosecutions and enforcement activity. All right, let me stop there, and we've got a couple of minutes left. I will return to the question that was asked at the break, but I also wanted to find out if there's anything else the moderator wants to say or any other questions that we need to address first.
Thanks, Ed. I'd like to thank Ed Heath of the law firm of Robinson and Cole for offering his time and sharing his knowledge and experience. We will now move to the Q&A portion of the webinar. Melinda, can you please provide the audience once again instructions on how to ask a question by phone?
All right, we will now start with the second session of the Q&A. In order to queue for a question, please press *1 and clearly record your name for a question introduction. Again, to ask a question, please press *1.
All right, thanks. And everybody, as we sort of wait for phone questions to chime in, I just want to remind you that Anthony will send out the recording and presentation of this webinar by Friday, 9 a.m. Eastern Standard Time. And I don't see any written ones. Tony, do you see, since you're the master organizer, do you see any other Q&As? Or Ed, do you see any coming in the box? I only see what we.
Do you want to address that one that you had from the break, and then I think I have one more that was written in afterwards here.
You bet. So let me go to the one which was asked about prosecuting overseas individuals. And the bottom line is there was a case on this recently involving Alstom Power, ALSTOM, for anyone who wants to read the decision. But essentially, the FCPA, can't be used to prosecute an individual with no ties to the United States. That was the issue in that case. Even if there's an underlying crime, DOJ, can charge a foreigner only if they can show that she committed the crime while present in the U.S., while working as an agent of the U.S. company or of a foreign company whose securities are traded on the U.S. exchange or an over-the-counter market, or widely held in the U.S. So you really need that more direct tie to the U.S. to reach foreign nationals.
All right, thanks, Ed. The other one written in here is, can FCPA be applied post facto to people who are former government officials?
If I understand that question to be, so they did something in their work as a U.S. government official, but now they're out of the government in their private capacity, almost like one of the questions that the court's been wrestling with about the current president. If I'm understanding the question correctly, I think the answer is probably no. That it wouldn't be it'd be a different set of laws that you'd pursue the individual for if they were making illegal bribes on behalf of the U.S. government while a U.S. government employee. If they're making if they happen to be a U.S. government employee, but they're acting as the agent of a private company in making the illegal payments, then I think they can probably be prosecuted for that conduct because it's in furtherance of a private company scheme.
All right, Ed, thank you. I'm going to ask the operator now if we have any verbal questions that came in the queue.
Actually, have one question in the queue. A name was not recorded, so I will introduce the question by the phone number, so please listen carefully. Phone number 603-540-0389. Your line is now open.
Thank you. Good afternoon. This is Pat Kazakis, and it's a question really on twofold. Part of the compliance program when you do an export is to screen your customers and potential customers. So if a customer comes up and you see that they want to buy your product and they have an FCPA a Foreign Corrupt Practice Act violation against them, you as a company, are you allowed to do business with them, or do you then take it internally and then, make some kind of policy that you don't do business with this type of company, or how would you handle something like that?
That's a great question, Pat. So if I understand your question correctly, you're contemplating a sale to a company, and you've learned that they've either been prosecuted and convicted, or they're being prosecuted and convicted, or they're being investigated for an actual or potential FCPA violation. So you know that you've got this issue. You know that they've engaged in those tactics.
Correct.
I would say you can still consider doing business with them. It's a red flag, like any other red flag. What you want to do is drill into what happened there. If it's an active matter, they might be reluctant to go into detail with you because they may be negotiating with the government. But I've actually been in a somewhat similar situation. And, we were able to tease out of the third party who was in the midst of an active DOJ investigation details about the investigation, details about the allegations and what was driving them. And in that instance, our client got assurances that that we felt comfortable relying on because they had the indicia of credibility, that the person on the other side of the transaction, or the entity on the other side of the transaction, had an employee who potentially had engaged in bad conduct. The company was debating whether it was illegal conduct, whether it was an illegal payment, but the company had disciplined that employee and terminated him. The agent that they worked with, they had terminated all dealings with that agent. The company did show us that they had a policy. It wasn't the greatest policy in place. It wasn't the greatest compliance program, but they did have one. And so what we saw was a discrete enough set of circumstances that our client ultimately felt like they made a business decision that they were comfortable moving forward. But I will tell you, Pat, they very carefully scrutinized all aspects of the transaction they were working on. They dotted every I, they crossed every T. 2 sets of eyes were in every piece of documentation. Every request was vetted twice. So, there shouldn't be, paralysis because of the FCPA. The government isn't trying to stop international business. They just want to make sure it's done carefully.
Okay.
Great question. Thank you.
Thank you, Ed and Pat. Appreciate that. Operator, do we have any other questions in queue?
Actually, that was the only question that I had.
Okay. Thank you. Appreciate that. Ed, we have another minute. I'm just going to ask you a little out-of-the-box question. And typically, I guess it's 2 questions. How often should a company conduct training with their employees on the FCPA? And then if you have any other recommendations for good resources for companies to review, if there's any good blogs out there we can share with them, or other kind of helpful links that we might be able to share, are there any other good resources out there that they could learn more about FCPA, the FCPA? Thank you.
Absolutely. Great questions. I'll take them in reverse order. Unlike a lot of federal statutes, here the DOJ and the FCC have put out fantastic guidance in pretty plain language. I wouldn't say it's enough to sort of draft your own compliance program without the help of a lawyer, but it can get you a long way toward it. The sources that I've cited, the 3 sources I've cited, are really where I'd recommend that people go, and particularly the first one, the overall manual, the first thing that's listed in that slide. It is really a great user-friendly document. In terms of training, I recommend the training is done. You do an intensive training at the start, the first time you kind of get religion and roll out your policy, and you can do an abbreviated version. When we do our trainings, the first one is usually an hour to 90 minutes long. The refresher is usually about 40 minutes. I'll give you a little bit of sort of an inside tip that we use with our training. And I built into this PowerPoint some examples of those. I like to use the hypotheticals. And we use multiple choice questions in them. But we also have an internet setup where everybody who comes to the training brings their smartphone or their laptop or tablet, and they log into a website. And what we do when we do the training is we put the multiple choice question up on the board in the hypothetical. We get everybody's answers, and then we go to another screen that shows whether or not everybody in the room got the answer right. We don't shame the people who got it wrong, but we show, if the answer is A and everybody says A, great, we sort of give one line and move on. But if the answer is A and we get a couple of B's, C's, and D's, then we know there's people in the room who didn't understand the explanation we just gave. And we say, look, folks, let's walk through why B, C, and D aren't right. That's our way of later on showing if the DOJ comes knocking and they say, hey, your training wasn't effective. We can say, we know it was effective because we figured out where people weren't understanding us, and we went back and emphasized those points. So I'd recommend that to anyone doing the training. If your training doesn't have that, make sure it does, and I really recommend it being an annual exercise.
Thank you, Ed, so much for that. And we really appreciate, Ed, your participation and giving us the presentation today, and also want to thank Robinson and Cole for this. It was really enlightening. What we'll do is, like Brian said, we will get that the copy of the recordings from this week out by 9 a.m. tomorrow morning. I think they'll be completed by then, no problem. We'll get the resource materials out as well. Everyone have a nice rest of your day. Appreciate it.
Thank you.
All right, this will conclude today's conference. You may now disconnect.